What's up, viewers, subscribers, and agents alike? It's your boy Enlightened Luciferian Prince coming at y'all once again. Now, I know that I told you people in regards to my previous video, I said, listen, y'all just go ahead and stay tuned for the tax information. But I'm going to also tell you how in certain situations, before we proceed, this does not constitute legal advice, nor does it constitute anything anti-government. The sole purpose of this video is for informational and educational purposes only. But I want to tell y'all about something in regards to tax matters, and that actually has something to go. It coincides with what we call the Fifth Amendment. Now, as perfunctory as we know the Fifth Amendment is, against public pretense of actually being protected against self-incrimination. That doesn't apply in all matters. Now, I'm here to define the very fine line that coincides with this reason. And I have very good legal reasoning which actually can support my theorem in regards to this matter. So stay tuned. Let's talk about it. Fifth Amendment abuses. Before I proceed, this might get a little rough. My videos are not for children. So if you're watching this around children, please remove your children from the space. Pause the video. Videos are not made for kids. They're for adults only. So let's roll. Fifth Amendment abuses. Constitutional privilege against self-incrimination applies to civil as well as criminal privileges. Now, this is McCarty versus Einstein, 206, United States Supreme Court, 3445, SCT 16, 1924. Now, let me show you how that drastically changed. Judges and government lawyers are aided in their abuse of our liberties by deliberate and flagrant violations of the Fifth Amendment. The Fifth Amendment says, no person, which is corporate, shall be compelled in any criminal case to be a witness against himself. What they will tell ignorant litigants opposing to government is that the Fifth Amendment only protects testimony in a criminal trial, not a civil trial, such as those involving taxes. The judge will then threaten to sanction such a litigant for contempt of court if he does not testify against himself, hoping that he will provide enough information, which is nothing more than subject matter jurisdiction, to make the government's case. However, this approach violates the precedents of the United States Supreme Court, lowercase s on Supreme, which said on the subject, the Fifth Amendment, put it in brackets, privilege reflects of a complex of our fundamental values and aspirations and marks an important advance in the development of our liberty. It can be asserted in any proceeding, civil or criminal, administrative or judicial, investigatory or adjudicatory. And this is the citation, Volume 406, United States Supreme Court, page 441 through 445. Protects against any disclosures that the witness reasonably believes could be used in a criminal prosecution or could lead to other evidence that might so be used. This court, quote unquote, has known to be a zealous safeguard of the values that underlie the privilege. That is a quotation from Castigar versus United States, Volume 406, United States Supreme Court Reporter, page 441, year 1972. Why do you think the Fifth Amendment protects testimony even in a civil or tax trial? The reason is because a criminal trial could result from the testimony in a civil trial. This is what the Supreme Court calls a derivative use. Quote, derivative use. If the government puts you on the stand in a civil trial related to the imposition of penalties and the payment of a tax and finds out that you committed criminal fraud based upon your testimony, your own words, then they use that as evidence. Consequently, you can confidently assert the privilege in either a civil or criminal trial and the government wants to compel you. Then all you have to do is demand immunity under Title 18, United States Code, Section 6002. The ruling in Castigar upholds the doctrine that such immunity, although granted by the federal government as a sovereign, also affords immunity from state prosecution as well. And you just learned a very significant truth in less than 5 minutes. Now, when it boils down to tax law, and the reason why I'm coinciding this with tax and court is to give a better interpretation of jurisprudence behind what tax law is, what tax forms are, and how the judiciary looks at this as being compelling evidence against yourself. But to even make it more simple, when you file a 1040 and you put all the information that they need for that taxable year on that form, you make sure you enter all the address identities, or you enter the particulars and the norms, whatever. And then they turn around on the last line, they say signature. And it says, I, whoever the signee is, who's accommodating the document, according to UCC 3419, you're basically telling the IRS that I am basically swearing under penalty of the laws of perjury that all information placed on this form is true, correct, complete, to the best of my knowledge. Those are the 4 stanzas that actually are side contractual to when you actually file a tax form. So now that you do that, they take you on your word, make you sign it under penalty of perjury, and you just offer them all the subject matter jurisdiction to give them the ability to peer into your accruage of what you made throughout that year and to be able to tax you on it. And they can use that very form in tax court because you swore against it as yourself as a CPA and you're not even certified to do so. They don't care, because it all boils down to keeping you involved in some sort of contractual notion. It gets very simple when you understand that most of these things we deal with in society or law are all contracts. They are contracts that are created by constructs. Contractual. I don't care if it's verbal, because those really, in certain substances, unless you have witnesses, because you have to understand this goes to the Old Testament precept as well. Unless you have somebody hear what you said, your word really can't be taken for, quote unquote, granted or being accepted, because no one heard it. Now, if it's 2 people or more witnesses, now what it has become is a verbal contract. It's still an understanding and an agreement to operate on something. You know, that's why I tell people, we even grew up in our lives when they told us never make a promise. Don't do that, because you're not guaranteed to fulfill something you're not really sure about. You know, well, I'll go wash the car, honey. I promise I'll do it later. Don't do that, because you don't know if later gonna come. And that leaves something unfulfilled. That's a verbal agreement. So now you also get the notion more in the principlistic state of why they actually want you to start talking or make you compel evidence against yourself. Because a lot of people will freely and voluntarily give up personal information. Serious. You know, cop pull you over, people go to talking to them like, hey, you know, like that's they mama. You know, they go to talk and spill all the beans. Nah. Chill. Don't give more information than necessary, and only require or furnish certain information when it is necessary, not more than what is actually required. Because sometimes that's one of the reasons why in these processes a lot of people get shut down, because they do overkill. Serious. Sometimes got to keep your zip closed on paper and in public. You see what I'm saying? So I just drew a parallel right there. So those people who are rocking with me, keep rocking with me. You know, hopefully everybody's in a good state of mind. Everybody's out there prospering, making sure that they got their own little mojo going. I know we all hit road bumps, but it is what it is. You know, hey, it's like we're mature. We can handle it. But what we need to do, instead of getting caught up in certain drama, is make sure that we can actually prosper and focus as individuals before it all falls down. So, peace, light, love. Take care. I'm out.